Hello, friends. I welcome you all to this session of Indian Law of Evidence. This is our 34th session and last one relating to Chapter 5. A brief overview of what all we are going to study. We will see what are the various presumptions as to documents, what are the presumptions regarding certain documents, and the two types of presumptions which are there, that is, one is compulsory and another is discretion. That is what we say shall presume and may presume, which we have already seen in our previous sessions. uh, Before, what is important in this is that from section 79 to 90, that one should know in which section what is related to it. Many a times match the following is given or section is given, and what is asked is that what it relates to. So we will start with one maxim, and I will just write this maxim: omnio prosumptur right esse acta. Omnio presumptur right esse acta. Remember it may be asked in prelims that what does it means. It means that all acts are presumed to be rightly done. So omnio means all, presumpture means presumed, right means they are rightly, acta means act, essa means done. So omnio presumpture right esse acta, all acts are presumed to be rightly done. So one of our basic presumption is whatever is done has been done, we will presume that it was done in the correct manner, and we will not be suspicious about everything else. Then the whole, it will be like seeing the whole world as wrong. Now, two types of presumptions are there between section 79 to 80, section 79 to 90. One presumption is shall, and another presumption is may, that is shall presume or may presume. Now it is also to be remembered that where there is word shall and where there is may. So as we know that the word shall is compulsory on part of court, that is, the court will compulsorily presume it, while as far as may presume is concerned, it is discretionary on part of court to presume it. However, both are rebuttable, that is, the other party can give evidence to rebut that this presumption does not stand. Now just remember, as I have put here also a figure so that you can remember, 1986, the Consumer Protection Act is of 1986. So just remember 86. Why? You will come to know. As far as shall presumption is concerned, 79 to 85 and 89. So from here I take this 8, and from here I take this 9, 89. So these sections are regarding shall, 79 to 85 and 89. How I come to it? 79 to 85, then here I write 8 and here I write 9. So these sections are regarding shall presume. And for may presumption, remember this 86, the Consumer Protection Act. So 86 to 87, 88, 89 has already been covered here, and 90. So these are may presumptions. certainly 90A will also come here. So this remember that what are for shall and what are for may. Now first we'll, as usual, we will go for acronym so that we will be able to remember what is there in which section. So just I have put three figures here and you have to remember these three figures only. What it says is that, as you can see here, we have there is a CD. So remember CD, compact disc. And what is this CD? This CD is of general studies. So general studies is also written as GS. So CD for GS. These is for section 79 to section first four sections 79 to 83. So just see what it is. So section 79, C stands for certified copies. So if a certified copy is produced, then the court shall, as we saw it, it is shall. The court shall presume, what it will presume? Two things: that the copy is genuine. As far as genuineness of copy is concerned, the copy is genuine, and the officer who has signed it has the authority to sign it. So these are the two presumptions as far as this is section 79 is concerned. We'll just read it out. Presumption as to genuineness of certified copies. The court shall presume, so the word here is shall presume, to be genuine every document purporting to be certificate, certified copy or other document which is by law declared to be admissible as evidence of any particular fact and which purports to be duly certified by an officer of central government or state government or by any officer of Jammu and Kashmir who is duly authorized thereto by central government, provided that such document is substantially in form and purports to be executed in the manner directed by law in that behalf. The court shall also presume that any officer by whom such document is purports to be signed or certified held when he signed it the official character which he claims in such paper. So what it says, that in case there is a certified copy and that certified copy has a signature, seal, date and true copy written on it, then we will say that this is a genuine copy. First thing. Second, the officer who has signed it had the uh, authority at that time when he signed it. So there is a date. At that time when he signed it, he has the authority to sign it. It should be in proper form. Then these two presumptions shall be raised by the court. Remember, again, I will tell you it is rebuttable as such. So that is what is section 79. Next, section 80. 80 is D, that is deposition. So as you remember, deposition is whenever a person comes in court, to a witness comes in court to give evidence, we ask him or he gives evidence, we record that evidence at a particular place. Now a certified copy of this record is produced, then it shall be presumed that it is a genuine certified copy and the statement was duly recorded. That is, it was done in the manner it should have been done. This is again based that all acts are presumed to be rightly done. So just we'll read section 80. Presumption as to documents produced as record of evidence. So these are the documents which are produced as record of evidence. Whenever any document is produced before any court, purporting to be record or memorandum of evidence, so that record is what? Record is regarding the memorandum of evidence of any part of evidence or any part of evidence given by a witness in judicial proceeding or before any officer authorized by law to take such evidence, or to be a statement or confession by any prisoner or accused person taken in accordance with law and purporting to be signed by any judge or magistrate or any such officer as aforesaid, the court shall presume that the document is genuine, that any statement as to circumstances under which it was taken purporting to be made by the person signing it are true, and that such evidence or statement or confession was duly taken. So, if a judge or magistrate or any officer who is so authorized takes any evidence, records any evidence, signs over it, then it will be presumed, and a certified copy of it is produced, then it will be presumed that it is a genuine copy and it was duly taken. That is, no, um, the there was no mistake or no procedural fault made on part of the judge or magistrate. This is shall presumption, however, it is rebuttable. Next is G. G is section 81, where we talk of gazette. That anything that is published in official gazette, newspaper, or private act, then we will say that it is genuine as such, a genuine document. However, we will read it. It has got one important point which I want to highlight, and that is regarding newspaper. So, first, let us see what it says. Presumption as to gadgets, newspapers, private acts of the parliament, and other documents. The court shall presume the genuineness of every document. So, the document will be genuine, purporting to be an official gazette of government, or to be a newspaper or journal, or a copy of private act of parliament, and every such document purporting directed by any law to be kept by any person, if such document is kept substantially in the form required by law and is produced from proper custody. So, two things, as we have seen in certified copy also, that it should be in that particular form, it should be from proper custody. If it is produced, then any gazette or newspaper or journal, we will take it to be a genuine document. But will the contents that is produced in newspaper will be will the newspaper constitute truth regarding it? That is, if the report is there in newspaper, then will that content of that report will also be presumed to be genuine as per section 81? Then the answer is no. In Lakshmi Raj Sethi versus state of Tamil Nadu, this is AIR 1988 Supreme Court. Now, in this case, it was particularly held that the newspaper report do not constitute, remember the word, do not constitute admissible evidence of their truth. So, if a particular thing is reported in newspaper, we cannot just say that this is true because it is reported in that particular newspaper. No, the presumption that will be raised in the section 81 is that such thing was reported in a newspaper. As far as the truth of the content is concerned, content of record is concerned, that will not be proved just by newspaper report. So remember, there are two things. One is the genuine, that presumption as to publication of report, and another is about the truth of report. that the report is true. This is not presumed as far as section 81 is concerned for newspapers. But such publication was there in a newspaper, that will be presumed. Okay. So remember it. Next is your section 82. 82 is regarding this. G has been done. This is S. It will be only 82, sorry. So 82, it is regarding the presumption of document which will be admissible in England without proof of seal or signature, as it was made, the Evidence Act was made in 1872 when we were under British rule. So it says, what it wants to say is that the evidence that if there is a document and that document has got certain signature, then some document will be acceptable without even proof of these signatures. So I have put it as signature, that a document will be admissible bearing a signature and seal, but that signature and seal need not be proved in certain cases. So what, we'll just see what section 82 says. Presumption 81A is also there. 81A says presumption as to gazette in electronic form, that if a gazette is published in electronic form and it is in particular proper form, it is in proper custody, then the presumption will be that it is correct. Now 82, what we were studying, presumption as to document admissible in England without proof of signature or seal. So when any document is produced before any court purporting to be document which by law in force would be admissible in proof of any particulars without proof of seal or signature or stamp authenticating it, or of judicial or official character claimed by person by whom it purports to be signed, the court shall presume that such seal, stamp or signature is genuine, and that person signing it held at that time when he signed it judicial or official character which he claims. What it is saying, that suppose this is a document and this document has got a signature and a seal of an officer, government officer, whether he be judicial or executive, then it, even without proof, there is no need for court to ask for the proof of the sign and seal, whether that particular officer was holding that particular post or not. Court will shall presume that the sign is correct, genuine, the seal is genuine, the government officer at that time held that post genuinely, and he had the authority to sign and put his seal. It is the for the opposite party now to rebut it. So that is what is section 82. Now we have seen CD for GSCD. Now we will see MLA. This is MLA, it is for section 83, 84 and 85. Member of Legislative Assembly, as you can you have studied in your polity. So 83 stands for presumption. M stands for maps. So what it says is that if there is a map or plan and that map or plan is published by the authority of government, then the court shall presume that it is accurate. So accuracy of maps or plan will be presumed as such. We will just study what it says. Section 83, presumption as to maps or plans made by authority of government. The court shall presume that the maps or plans purporting to be made by authority of central government or state government, where so made, are accurate, but maps or plan made for the purpose of any cause must be proved to be accurate. What it says is that simple, that any map is there, any plan is there, and that has been made by authority of government, then the court shall presume its accuracy. that it is accurate. However, what will be open for the other party is to rebut it. So that is what is M. Next is L, that is 84. This is regarding law reports or law journals. So as we have seen that there are many law journals where judgments of Supreme Court or High Courts are being published. We will, if it is published by the authority of the government, then we will presume its genuineness, shall presume. So it is again for the opposite party open to rebut it. But if a book is produced and that book gives cites certain laws or says certain judgment, then the court shall presume that okay, it is correct. Now the opposite party may give evidence to rebut it. The court do not have power in such cases to deny its genuineness until unless it is rebutted by the opposite party. Presumption as to collection of laws and reports of decisions, section 84. The court shall presume the genuineness of every book purporting to be printed or published under the authority of government of any country and to contain the laws of that country, and of every book purporting to contain report of decision of court of such country. So if there is a book and that book or journal and that book or journal has been published under the authority of the government of that country, the court shall presume it to be genuine. Now, section 85, that is A, it is attorney. This is presumption regarding power of attorney. So it says that if there is a power of attorney has been given and that has been duly executed before a government officer like notary public or judge or court, then in that case it shall be presumed to be genuine. That is, it shall be presumed that it is correct. However, again it is open for the other party to rebut it, but it is not open for the court to not accept it in the first instance. We'll just read it. Section 85, presumption as to power of attorney. The court shall presume that every document purporting to be power of attorney and to have been executed before and authenticated by notary public or any court, judge, magistrate or counsel or representative was so executed and authenticated. So two things, that if there is a power of attorney and it has been properly executed and authenticated, then these that it has been properly authenticated and executed, it will be presumed as such. Now we will see. So as you have seen in YouTube that this is whenever you see a video and want to repeat it, then this sign comes. If you do not want to repeat it, then sign is this. So now our next sections, which are from 86 to 90 or 90A, is based on it, that is R E P E A T, repeat, no, then don't repeat. So remember that these I have kept in a small because they don't represent anything, only consonants here represent. So R, section 86, and this R stands for, this is regarding the records that is given by foreign court so judicial records that are given by foreign court, and if any book or journal is produced and that book or journal has been published by the authority of that particular government, foreign government, then the court shall presume, sorry, the court as we saw, 1986 is there. The court may presume that the court may presume that the certified copy of it is genuine. So, if there is a certified copy and that certified copy is regarding a record of foreign court or judicial record of some foreign court, then the court it is open for the court, it is discretionary for the court may presume it to be correct or genuine. We will see, just see section 86. Presumption as to certified copies of foreign judicial record. The court may presume that any document purporting to be certified copy of any judicial record of country not forming part of so and so is genuine and accurate if document purports to be certified. So, if there is a document certified copy produced and it says the party says that this is a certified copy of foreign court foreign judicial record, then the court is discretionary upon court to accept to make the presumption or not to make that presumption. So that is section 86. Remember, it is may, not shall. Then 87. 87 RP, this is regarding your publication. Here, what the again this is may presume, as these all are RPT, no are may presume except for one, that is 89. So what it says is that if there is any publication and that publication has written that it is published by so and so person from so and so place, then the court may presume that it has been published by that person and it has been published from that place. I will just read section 8. Presumption as to book, maps and charts. The court may presume that any book to which it may refer for information on matter of public or general interest, and that any published map or chart, the statement of which are relevant and which is produced for its inspection, was written and published by the person and at the time and place by whom or at which it purports to have been written or published. So, if there is any publication of book, maps or charts, and that publication mentions that it has been published by so and so person at so and so time at so and so place, then the court will the court may presume that these are correct, that it has been published by such and such person at such and such time in such and such place. Now RP will come to T in section 77, section 78, 88, that is T, and here this T stands for telegraphic message. What presumption is that? Suppose a telegraphic message is being sent from A to B, then the presumption are that it has, and here it is sender's name A is written, then it is will be presumed that A has sent it, and this is the content which has been received by B is the content which has been sent by A. So two things regarding the content that is received is same as the content which was transmitted. The person who has sent it is the same. It is, but remember, the presumption is not about to whom it was addressed. The court may presume that the message delivered to the addressee, that is B, corresponds with the message handed over to the post office, that the same message was handed over, and that the message was meant for the person whom it is purported to be delivered, that the message was for B, but it shall not presume court shall not make any presumption as to sender of message. So the message sender is A or not, this presumption will not be done. So presumption will be regarding only two things, that to whom it has been sent, to whom, and regarding the message which has been sent. And there will be no presumption that the message has been sent by whom. So there will be no presumption regarding by whom message has been sent. There will be presumption only regarding to whom it has been sent and what message has been sent. So no presumption will be regarding A, presumption will be regarding the B, the receiver. Same 88A is there regarding electronic mail, that whenever a person say B receives an electronic mail, then what will be presumed is that it was sent to B and the message transmitted was what the message which was received. However, who has sent the message will not be presumed. Next is section 8, REPT and then N, that is 89. This is regarding not produced. Now this is something which is not usual, which does not usually come in our mind. For example, if we ask someone to bring something and he does not bring, then we presume that kuch na kuch garbar zarur hoga, something must be wrong, so that he is not producing it. But the Evidence Act says that no, this is a wrong thinking. What we should presume is that we should, like good person, presume that no, it has been proper, it document must have been proper, but because of some reason he is not producing it. And remember, this is shall presumption. What it says is that every document, so suppose court has called a document A and it has asked A to produce a document, and A has not produced that document. Now, the court shall presume that this document was attested, stamped, and executed in the manner in which it is required by law. We will not presume that the document is wrong and therefore A is not producing it. The court shall presume that every document called for, that document has been called for and not produced, but it is not produced after notice to produce, that A has been given notice, but he has not produced. The court will not presume that it is not correct document or it has not been correctly attested, stamped or executed. Rather, it shall presume that the document was attested, stamped, and executed in the manner required by law. So, what we will presume is that what the we started with the maxim, with all acts are presumed to be rightly done. So, that is what is section 89. Next is section O, that is old records. This is section 90 and 90A. 90A is regarding electronic evidence, electronic records, and 90 is regarding the documents. So those documents is what it says, which are 30 years old or more. So documents which are 30 years or more, and it has been produced from proper custody. So proper custody has also been determined here, that proper custody means that custody from where it would normally be, and from a person, that is places where normally it will be. So if it is an official document, then its normal place will be the office, and person in whose custody it should be. So it should be in clerk's custody, office clerk's custody. So if a document is 30 or more year old, it is produced from proper custody, and proper custody meaning from proper place and from proper person, then we will say that it was attested and executed. The court may presume that it was attested and executed by the person whose signature is there. This is what is regarding 90. In case of 90A, it is electronic record, and here the period is only 5 years. That if there is an electronic record 5 years or more old and it is produced from proper custody, then we will see, then we can may presume that it bears the digital signature is correct. We will just read section 89. Presumption as to due execution etc. of document not produced. The court shall presume that every document called for and not produced after notice to produce was attested, stamped, and executed in the manner required by law. So we will say that even if it has not been produced, but it is proper. But remember, it is shall. And 90, that when any document which is proved to be 30 years old is produced from any custody which the court, or a proper custody, the court may presume that the signature and every part of such document purporting to be in handwriting of any particular person is in person's handwriting, and in case of a document executed or attested, it was duly executed and attested by the person by whom it purports to be executed or attested. So if this is a document, so we will say if it is from proper custody and 30 years or more old, then the handwriting we will presume. Then we will presume if it is executed, execution we may presume, and if it is attested, its attestation also we may presume to be correct. Now, proper custody has been defined. It says that documents are said to be in proper custody if they are in place in which it would normally be there and in care of a person who has the legitimate power to keep it. Now, now section 90A, as we saw, that presumption as to electronic record of 5 years old. Remember, this question is asked many times, that section 90 relates to may presume, and in case of physical document the period is 30 years. In however, from state to state it may differ, so you should see that also if you are appearing particular state examination. And for electronic record it is 5 years, where any electronic record purporting to be 5 years old is produced from any custody which the court in particular case considers proper. So custody is proper, it is 5 years old. The court may presume that electronic signature is of that particular person. So this is what is section 79 to 80, or the various presumptions regarding document. We'll just revise it once more, as we have seen that the maxim is omnio presumptio right esse acta, that is, which means that all acts are presumed. It means that all acts are presumed to be rightly done. Then there are two types of presumptions, shall and may. Shall is compulsory and may is discretionary, but both are rebuttable. Then shall is from section 79 to 85 and 89, where 8 is taken from here, 9 is taken from here. May is from 86, 87, 88 and 90, 89 is not there. Then we saw that C, we can remember it as CD for GS 79 to 82, where C stands for certified copy. In case of certified copy, the court shall presume that it is genuine and has been signed by person who had the authority to sign it. Then in case of section 80, we saw that if there is an record of deposition, then we shall presume that it was properly taken and it is genuine. In case of section 81, it is regarding gadget, that if there is an official gazette, we will presume it to be genuine. However, in case of newspaper, the publication part will be taken to be genuine, but the content part will not be taken as genuine. Then section 82, which is regarding certain documents where there are government sign and seal, the court shall presume that it is signed and sealed by appropriate person and it is genuine. There is no need to prove the signature and sign of the government official. Then section 83 is there regarding maps and plan, and it is also shall that if a map or plan has been published by the authority of government, then its accuracy is presumed. Then L stands for law journal. If there is a law journal, then the reports published in law journal is shall be presumed to be correct, provided it is published under the authority of government. Then A stands for A, power of attorney. If there is power of attorney and it has been duly executed and authenticated by the government officials, then what will assume is that it has been the execution and authentication part will be presumed to be genuine. Then we saw there is may presumption from 86 to 90, which is repeat no. R stands for record of foreign court. So if a certified copy or is produced regarding record of foreign court and it has been signed and properly sealed, then the court may presume it to be genuine. Then P stands for publication by, so if there is any publication of book, map or chart, then the court may presume that, and it is mentioned that so and so person has published it at so and so place at so and so time, then regarding these person, place and time, the court may presume. Then we saw T regarding telegraphic message, and 88A is also regarding electronic message, mail, that the person to whom it is sent and what is sent may be presumed, but by whom it has been sent will not be presumed. Then section 89, which says that if a document for production of which notice has been given, yet it doesn't produce it, then it will be said that regarding handwriting, attestation, stamp and execution, the presumption will be that it has been properly done. Then 90, where we saw that if a document is 30-year or more old, physical document produced from proper custody, then we will see that it is in that particular handwriting. Regarding handwriting, we can presume its attestation, we can presume, and its execution we may um, presume, provided it is in proper custody. Proper custody means normal place from where it should be and custody of proper person also. Regarding electronic record, it is in 90A and the time period is 5 years. If it is 5 years or more, then the court may presume that the signature or digital signature is of the person who whom it appears, whose signature it appears to be. That's all. Thank you, friends.